Yes, Mr. Price.
Before the short adjournment, I identified the three possible interpretations as I saw it.
Yes.
The historic test, the forward-looking test, and the tendency test. The tendency test being one that requires the court to exclude any probative facts in relation to causation and damages other than words. And that's the test that is being contended for by the applicant. And it's the only one that fits with the judge's findings of fact in this unusual case of limited publication. Those findings of fact are not an issue in this appeal. There was an attempt before the judge to raise some grounds.
Speak up a little.
There was an attempt before the judge to raise some grounds of appeal on the findings of fact. The judge rejected that, and there's been no attempt to reopen such challenges before this court. So we are left with the judge's findings of fact, which this court must accept, I would respectfully submit, when considering the application of the correct test to the facts of this case. There's no opportunity to reopen those facts, and the material facts in this case are really quite straightforward. There were only 2 publications. Each publication was to a single publishee. In the case of Mr. Butler, who was a potential client, he had already decided that he wanted nothing to do with the claimant. I simply state this neutrally. I'm not trying to argue for any sort of moral accounting, as the judge put it. I'm simply reciting neutrally the facts as found by the judge. He had found her to be a nightmare from the start of his dealings with her, and he didn't want to have anything to do with her. If one is allowed, that fact is obviously highly probative on whether publication of the words to Mr. Butler was likely to cause financial loss. He's decided he's not going to have anything to do with her, then it's clearly not going to have any effect on him. It's not going to cause any financial loss. So if you include that fact in the interpretation selected, then claim in relation to Mr. Butler must fail. It can only survive if all that is necessary is the words have a tendency to cause financial loss. And then it wouldn't even matter if Mr. Butler was a person who potentially the claimant could do business with. She could be just, my client could have just gone down the street randomly stating to a passerby those words, and they would still be actionable.
No, they wouldn't be actionable, because if you send them to a passerby, they would not be calculated to cause financial loss.
Well, that's not
pecuniary loss.
The claimant's submission is it's simply the words and the tendency of the words.
No, it's not. It's the words as spoken to the particular person they're spoken to. The question is whether that is calculated to cause pecuniary loss.
If I just break that down, the words as spoken to the particular person, I mean, that's the words. The identity of the particular person is something extraneous to the words.
Well, aren't you setting up an Aunt Sally? They haven't said this, have they?
Well, we're not clear exactly what it is. They say the court must not consider, but that it is being put forward as an exclusionary.
Well, it's not being put forward as an exclusionary rule. You're characterising it in that way. It's being put forward as a rule that requires attention to some things.
Well, then I would submit that there's also a requirement to have attention to other things which are probative on financial loss.
I don't think it's very helpful to characterise it as an exclusionary rule. It's a rule that says this is what you look at. And by definition, it's exclusionary of other things. But that doesn't really help advance the argument.
If that's the court's feeling, I submit it is an exclusionary rule, but if we could prefer me to put it another way round, the judge was entitled to rely on the facts that he relied on, that any Section 3.1 test must incorporate the ability of the court to rely on such facts as the judge relied on to find that there was no financial loss, and none was likely as of the date of publication. Financial loss remains the gist of the tort. I mean, the section refers to pecuniary damage. It's still an economic tort based on pecuniary damage. It's just a question of exactly what needs to be proved. Pecuniary damage in some way has to be proved. So the fact that,
Well, that's what you're asserting. The statute doesn't say that.
well, it uses the word pecuniary damage.
Yes, but it uses it in the context of whether the publication is calculated to cause pecuniary damage.
Yes. Well, if we starting just with the word pecuniary damage, that's financial loss. There's nothing. So then the question is, what must be more likely than not in relation to the financial loss? And in my submission, it either is that it's more likely than not that it has been caused, and that would address the mischief of the section. So the trial judge doesn't have to worry about special damages or anything of that kind, just has to decide on the balance of probability. Looking back, that this publication is more likely than not to have caused some kind of financial loss. Or alternatively, a forward-looking test, as at the date of publication, taking into account the probative circumstances, it was more likely than not that some financial loss would be caused.
I mean, the actual word calculated is more, if I can put it this way, more forward-looking than backward-looking.
Yes, I would. It is well, it's perhaps a tense. Is calculated.
Yes, that's right. We've substituted for those words the more likely than not.
Yes.
In essence.
I think we've calculated means more likely than not, but they haven't dealt with the is, maybe.
Yes.
So maybe this court is dealing with the is.
Yeah.
And
Okay.
I'm submitting that if it's an is, it's forward look. If one is adopting a forward-looking test, it's forward-looking from the date of publication as to whether financial loss was likely. And my submission is that the correct interpretation is actually historic, and that when we come on to principles of statutory interpretation, that's perfectly acceptable as an interpretation. If I was to just look at the statute and say, just in absolutely uncertain terms, what a historic test would in fact be saying, the statutes that tab 36 on page 805, second authorities bundle.
Sorry, could you just give that tab which?
Tab 36,
Yeah.
page 805. So it's obviously 31A. If the words upon which it has to be, if the publication of the words. It's the first thing. That doesn't deal with the is, has, but it takes it into the circumstances of publication, which is clearly what the section is directed to, and that's what was said in clear terms in Sellers and Griffiths. So it's the publication of the words, which the action is founded. It would be an is because it's the publication. Publication of the words upon which the action is founded is calculated to cause pecuniary damage to the plaintiff. I would accept that just looking at that, it would suggest you look forward from the time of publication. But in my submission, it's perfectly open to this court to, after the word to add a have, and at the end of cause to add a D.
Why?
Because that is in accordance with Article 10, because it would prevent an action it would prevent liability being imposed where no financial loss had been caused. And you could absolutely demonstrate that no financial loss had been caused.
But are you saying that the alternative interpretation would be incompatible with Article 10? Because otherwise that submission doesn't go anywhere, does it?
I am submitting. This has all been tied to the facts of the particular case, so one has to look at it as in the wider sense as an interpretive tool. But if that,
Well, no, that's not right, is it? I mean, if you're relying on the convention,
yes,
you have got to say that in these particular circumstances, this would lead to a breach of the convention. And therefore, in these particular circumstances, it must be interpreted in this way. You can't say, well, it isn't a problem in this case, but it could be in others, and therefore you must generally reinterpret article that reinterprets Section 3.
I think
There's plenty of case law about that.
well, obviously the interpretation's got to apply in all scenarios. So I'm not.
So the interpretation?
So, Section 3.1 has to apply in all cases.
No, it doesn't. That's the whole point.
Well, if I can.
You have to reinterpret Section 3. You have to reinterpret a statutory provision sometimes, applying Section 3 of the 1998 Act. Where to do so would, where not to do, where an ordinary interpretation would lead to a breach.
Yes.
That doesn't mean that you can do so in all circumstances, even where it wouldn't lead to a breach.
It would always lead to a breach because every time a claim would be brought, there would be an interference with the Article 10 right. These are the submissions that I developed. The very fact of being sued for malicious falsehood is an infringement of the Article 10 right.
It's an interference.
It's an
interference, not
yes, sorry, forgive me, Will. It's an interference.
Which could be
but
justified.
It requires justification. So,
As an innocent abroad in this area, why is it an interference with Article 10 to maliciously promulgate a falsehood about somebody?
that's, with respect, not the correct way of looking at it. The right is the right to communicate. So the starting point is there's a starting point. There is a generalised right to communicate, and then that can be subject to restrictions where the rights of others are engaged. And I accept that in those scenarios where the rights of others are engaged, the fact that something is false or it's been maliciously published can be relevant to restrict the Article 10 right. But the start point is the freedom of expression in relation to communication.
No, I'm looking at Article 10, but your point, if I understand this, is you have a right of freedom to express maliciously falsehoods about people, provided that you don't cause them financial loss.
Well, that's not quite what I'm saying. I'm saying, and it's important to actually have the taxonomy right when one's talking about these rights. There's two things I want to say. The first relates to the act of publication. The second relates to the act of being sued. And my submissions were directed to the act of being sued with a claimant who can take advantage of section.
Sorry, can you speak up a little?
My first point related to the act of publication. The second point related to the act of being sued. Which is
I understand what you mean by being the act of being sued.
Well, the bringing of an action against a person in respect of the exercise of their Article 10 right is a restriction in itself. There's clear authority for such a proposition. This
is all getting very complicated and unnecessarily complicated, isn't it? You have got to show, your proposition is, as I understand it, that in all circumstances, for that position, at least in these circumstances, it is unjustified to restrict someone's right to speak falsely and maliciously about someone else, where they won't suffer any loss as a result.
Yeah, that's an unjustified restriction on the
well, why is that necessarily so?
Because you start from there being a general right to freedom of expression.
Yes, of course.
And at that point, you don't look at the nature of the speech in terms of subject matter, because a lot of the European...
Keep it simple.
Don't look at the subject matter, you don't look at truth or falsity. There's that right. And then that right can be restricted where a right of another is engaged.
Yes.
And if there is no loss at all,
no financial loss
at all, there is no right engaged in relation.
Well, that's the bit I don't understand. The person might be very upset by it.
But this is not a tort which provides compensation for upset. There are plenty of...
Why? Well, you're assuming what you haven't yet proved. The Vice Chancellor in Joyce and St. Gupta would say it differently.
It's not. No, he's saying it's got to be connected with financial.
I'm not sure he says that.
His point is absent financial loss, there's no right.
No, absent financial loss or proof of the Section 3 circumstances.
Well, I mean,
no,
we better have.
Falls within the Section 3
This is the debate we had as to whether
pecuniary damage.
Yeah, I mean, there are.
Financial. Can I? Sorry.
Yes, no, I was just about to say, I mean, when we look at what the Vice-Chancellor said, there are 2 paragraphs in his judgment which don't necessarily match, I think, which we'll need to look at again.
It's an economic tort. Financial loss is the gist of it.
You keep saying that, but I don't know why you say it.
There's not been one authority.
Well, show us the authorities.
There's not been one authority where a malicious falsehood claim has been upheld solely on the basis of injury to feeling. That was noted in the McGregor passage that we've been to. All that's happened here, it's blindingly obvious with respect. What's happened is that Parliament has said that the problem with proving special damages, which we can, I mean, not so acute anymore in an age where there's documentary evidence, etc., but they think the proof of proving special damage is so high that there'll be cases where financial loss has been suffered, but it won't be able to be proved, so we need to relax the requirement of proving special damages. There's nothing to suggest that they were providing a remedy where it was clear that no financial loss had been caused.
Well, that may not have been the objective, but it could have been an incidental effect.
Well, if it is, it's over mission creep, and it's not been the way it's been interpreted by 3 binding decisions of the Court of Appeal, apart from anything else. There are 3 binding decisions which require proof.
You better show us these decisions. You're talking extremely generally at the moment. So this is blindingly obvious and so on, but show us the cases.
Well, I'm simply responding. I was asked to build a submission based on Article 10, which I'm trying to do.
Okay.
And I was confronted. I made the submission that absent financial loss, there's no right engaged in relation to malicious falsehood that would justify the infringement of KMC in Article 10 terms. And then faced with the submission, well, it's enough if there's been injury to feelings, which I will take it in any order.
I will pipe down and let you develop it, but at some point we need to see this.
I'm done. I would love to be of assistance. If the court wants me to go, I can go straight to those cases now.
But do it in whichever order you want. That's the best way of doing it.
Well, can I just finish with the Article 10 point, if I may. That interpreting Section 3 in the form of the historic test or the forward-looking test, which would not really offend the tenses within Section 3 potentially. That would adequately deal with the mischief of Section 3.1. All it would do would be prevent claimants where it was obvious that there was no financial loss, so that they wouldn't be able to succeed in the claim. And it's clear that Parliament wasn't trying to create a situation where a claimant who suffered no loss, financial loss, should be able to bring a claim for malicious falsehood. You've seen the references to very substantial harm, very substantial damage, and the inability to prove it. So that's.
While we're on the conceptual, before we get into the cases, can I raise with you the point that we encountered shortly before lunch? Take the situation where a malicious falsehood is issued. Published. Sorry. Published, yes. You correct. We've
got our own arcane language.
It's published, yes. And the subject of the publication, the claimant, learns about it and is distressed. Yeah. And at the time, it appears likely that it will cause him or her financial loss.
Yes.
If you stop the clock there, do you accept that they would have a cause of action, both for that they could bring an action using Section 3 without the need to allege or prove special damage? They would just say these words are more likely than not, by reason of the following factors. They'd have to put the particulars to cause me financial loss. In fact, I can rely on Section 3. In fact, I can't identify the special damage at the moment, doesn't matter. I can rely on Section 3, I can bring the claim, and I can piggyback onto my claim for general damage, financial damage, the injury to my feelings, which I'm currently suffering.
Yes.
That's within even what Sir Donald Nichols said in St. Gupta.
Well, forgive me, but I think one has to be really very precise about what's happened. So the words are at the date of publication, the words are likely to cause financial loss. Is that just because of the words or because of the circumstances in which they've been published? That makes a big difference in my submission. I have to look at the circumstances in which they were published.
Yeah, well, let's take the circumstances.
Yes,
they're published to
let's say
customers.
Yes,
So-
leaflet to a whole series of
Yeah,
customers.
so somebody says to a whole raft of customers, Mr. X has just been convicted of a criminal offence.
Yeah.
It's a fraud, don't deal with it. It's completely untrue. Okay?
And then the next day,
So he gets very upset
yeah,
and bundles down to court and issues his claim form
yeah,
using Section 3,
yeah,
saying, I probably won't ever be able to tell you how many customers I'm going to lose because of this, but it's inherently likely in those words communicated in those circumstances that I'm going to suffer financial loss.
yeah.
Section 3, you couldn't strike that out, could you?
Well, absent any, well, you couldn't strike out the claim. Absent any obvious counter causation factor.
Well, at this stage, there's a cause of action there, and he also says, and what's more,
Yeah.
I've suffered injury to my distress and injury to my feelings because
Yeah.
of this malicious falsehood,
Yes.
and that's another head of damage.
Yeah.
At that stage, constituted cause of action can issue a claim form using Section 3, couldn't be struck out.
Yeah, but it's a constituted claim form because of the likelihood of financial
Correct.
loss, not
In-
because
in-
of injury to feelings.
In the circumstance, yeah, but it's piggybacked, but you
Yes.
can piggyback it on.
And then if it went to trial and the judge found there had been some financial loss, whether it was
Right.
a kind of sort of the Code Morass case, or whether it be special damages, and that the injury to feelings was linked to that financial loss.
You know, okay, so the follow-up question is the one I asked before. Why should the claimant lose that cause of action? Either, certainly the one for distress, because he subsequently, before trial, in fact happens into a better paid employment, which is more advantageous to him than would have been the case if he'd stuck in his job with the customers he's been deprived of by the malicious.
Well, I mean, obviously this is not this case, but I mean, it's an economic tort, and therefore if you haven't suffered any financial loss, you can't recover injury to feelings in relation to it. And there's plenty of ways you could recover injury to feelings in other causes of action that are available, and we'll have to see this in the whole panorama of torts which restrain speech. But this is an economic tort, and if there is no economic loss because of a windfall, say, then there's no recovery for injury to feelings because it's got to be connected to the financial loss because it's a tort relating to it's an economic tort. And it's defamation, depending on what the words were, often defamation is available, and there you can get injury damages for injury to feelings. So there's possibly data protection rights could be engaged, who knows, privacy, there's all manner of ways in which Article 10 rights can be properly restricted on domestic law, but this particular tort, as is clear from all the authorities in the textbooks, is a tort of economic loss, and any right to reclaim damages for injury to feelings is parasitic on the economic loss having been caused. And whether it's just, it's really, not, in my respectful submission, not appropriate to invoke justice in a very abstract sense. This is not the trial of the claim, and this interpretation has got to cover a wide range of situations. There has always been a requirement, in addition to that of malice in this particular tort, of some form of damage hurdle. And there are very good reasons of policy why there should be meaningful damages hurdles. Now, this damage hurdle was special damage, and now it's general damage, like the financial loss. That it exists, but not with the particularity of special damage, because that's quite clear what's been said by, that's Parliament's intention clearly in section 3.1, and that's reflected in the Court of Appeal decision. So it's not a sort of palmistry justice situation. If it so happens that a defendant who's behaved badly escapes liability on causation, that's just a consequence of the law of tort being about compensation for consequential loss. If there's no consequential loss, there's no compensation. It's not a criminal case. There's plenty of crimes that can be invoked that restrain speech. There's millions of ways in which speech can be restrained in this country. We are having this argument simply because the judge has made two findings of fact which are fatal to the claimant's case, and the claimant's got the ability to push it forward on a CFA. That's why we're here arguing these points. The principle is quite clear. This is a tort involving damage, now financial loss damage, and the question is, what needs to be shown? Is it at the date of publication it was likely? Is it that it has been caused? It's certainly not correct that one just looks at the words in isolation without the circumstances of publication and determining whether those words to that category of person would cause loss. So there is no. That's clearly the domestic position in Article 10 terms. There's no necessary justification for proceedings being issued in relation to the exercise of speech rights in malicious falsehood, absence any loss having been caused or any prospect of financial loss being caused. There's no possible basis. It's an infringement of Article 10 that has no justification, no right, no human right can be invoked by the claimant in relation to this. She may have a right to refutation, but because Parliament has raised the threshold hurdle in defamation, she is unable to claim in defamation.
Can I ask a procedural question?
Yes.
What's the status of this Article 10 Convention argument in this appeal? Because as I understand it, no such argument was advanced in the after the event submissions below. It's not part of the judge's reasoning, and I'm struggling to find it in the respondent's notice, but I probably missed it.
It's an argument in relation to statutory interpretation, that the court should not permit an interpretation of Section 3.1.
Well, that's not really an answer to my question. What's its procedural status?
I'm entitled to make the submission as part of my submissions as the correct statutory interpretation. I'm making submissions on statutory interpretation that go wider than those that were put before the judge, as is, I think, the appellants. But we're here in the Court of Appeal to determine the correct interpretation of Section 3.1. That has to apply in all cases of malicious falsehood. I respectfully submit I'm entitled to invoke any interpretation that permits a claim to be brought where there's no financial loss, as the interpretation contended for by the appellant does.
Well, it does mean we don't have the benefit of the judge's view on this. And normally an appeal is a review of the judge's decision on the issues raised by the parties during the trial, or in this case, after the trial.
The judge, I mean, the Article 10. Well, let me reveal that. Looking at the authorities that the judge dealt with. I mean, this is not a new point.
That's really that's the short question.
Well, it's not a new point in terms of arguments on the law. I mean, it might be. I mean, for example, let me just trace the genesis. In terms of the point my Lord makes, I submit I'm entitled to make these submissions as part of my case in relation to statutory interpretation. The genesis of this invocation of Article 10 in relation to the construction of Section 3.1 starts with the case of Ferguson. I set these cases out in my skeleton argument.
No, I've seen the argument. To deploy the argument, I've seen it. Just wondering, just trying to establish that narrow point about what its procedural status is. You said you were entitled to run it, even though it wasn't run before, and the judge didn't deal with it because it's all part of the statutory interpretation.
Yeah, that's my respectful submission. It may be just helpful for perhaps the other members of the court. I may respectfully just draw attention to the overt invocation of Article 10 in relation to the interpretation of Section 3.1.
Sorry, can you speak up?
The overt reliance on Article 10 in relation to the interpretation of Section 3.1, which starts, it's in paragraph 45.5 of my skeleton argument on page 15 of the skeleton argument, page 64 of the bundle. It's the case of Ferguson and associated newspapers, an unreported decision.
I mean, if it's a very short point, I don't like being referred just to snippets. I'd rather see the case. But
yes, no, I think it's important to perhaps have a look at the case. So it's Ferguson. It's at tab 10 of bundle 1 on page 1112. Ferguson, and it was a suggestion that I think he was asking for money for interviews. And it was a strikeout application, and the relevant passage is on page 15 of the transcript, which is page 126 of the bundle, line 10. So this is the argument that has now been settled, the argument of what calculated meant, whether it meant more likely than not or some lower probability than that. And from line 10, the judge says, well, I can just simply let you read that. This is a paragraph beginning, in my opinion.
How much do you want us to read? 10?
Just that paragraph, in my opinion.
Okay. Yeah.
And crucial sentence, paragraph, line 19, and a wider interpretation of calculated in section 3.1 constitute an additional restriction of freedom of expression. So that's the invocation of Article 10 in relation to the meaning of calculated in section 3.1. And that passage of Mr. Justice Gray's judgment was relied on by Mr. Justice Lewison, who then was in IBM and Websphere Limited. That's referred to in paragraph 45.5.
Sorry to be a nuisance. Just for my note, Ferguson. How odd is there aren't page numbers in the transcript, but
well, I thought there were, because I put page 15 on my footnote.
You said that.
I can't see it, but it's page 126.
No, it's all right. I'll use the bundle numbers.
Page 126.
Sorry. Yeah. Okay.
Yeah, we don't seem to have internal page numbers, but it's 126.
Yes.
Yeah. No, I have it. It's just
maybe.
Thank you. Yeah.
And then that invocation of Article 10 relied on by Mr. Justice Lewison, who then was in IBM and Websphere. And the reference there is 112.173, although I'm not. That may just be to the start of the judgment. It's paragraph 74. That was a section 3.1 case. Justices Tugendhat in Carlos and Calvert. That's under 1, tab 25, and that passage 192 to 195 is at page 491. I can go to those passages.
These are all on the question of what calculated.
Yes, but not just that, but to rely on Article 10.
Yeah, your point, which I can't believe is contentious, is that in principle, in construing a statute, one should have regard to which is more likely to be in accordance with convention rights.
And that an interpretation that excludes claims where no damages have been caused, or no financial loss was caused or was likely to be caused, is not in contravention of any article that could be engaged by the claimant. None has been advanced on behalf of the claimant, none could be. So it's all one way at that stage. And then one has to ask, well, does the interpretation which I'm submitting Article 10 drives the court to, does that go too far? Does that fail to address the mischief of the provision and potentially prevent people from making claims where they have suffered meaningful financial loss? And obviously it doesn't do that. And there is one more reference to Ferguson, which is in Tesla, not in the Court of Appeal. If I can just give you the reference. It's Mr. Justice Tugendhat's judgment. It's at Bundle 1, tab 20, page 354, at paragraph 7.
These are the references you've given in your study.
There's one more.
Sorry.
There's another decision, Mr. Justice Tugendhat.
Okay, tell me again where.
It's at Bundle 1, tab 20, page 354, paragraph 7. It's the first instance decision.
Paragraph
7. It's the first instance decision in Tesla.
Yeah. That's all the point that's not in issue. But all
Yeah.
I was asking you was the procedural status of the argument.
Yeah.
And the answer is that it wasn't raised until the skeleton argument for this appeal.
Yeah, that's correct.
And the only point
so far as I'm aware,
is that it doesn't give your opponent an opportunity to deal with it in his skeleton beforehand. That's the only point. And it's a procedural nicety, some might think,
yeah.
to give notice of an additional reason why you say the judge was right, which wasn't one of the reasons that he gave.
Well, it is so. I apologise, but he does address Article 10 in his skeleton argument. He said it's not engaged because it's malicious, but that's plainly wrong because, as one can see, any interpretation of Section 3.1 is going to be to the benefit of malicious defendants, just as it will be to the benefit of non-malicious defendants, because that's the other side of it. The other side of the equation is people getting sued for malicious falsehood, having to rebut a case on malice, which is not straightforward to strike out, as these various authorities demonstrate, and put to the bother of fighting all this when the claim could be struck out ordinarily on the basis of any evidence of financial loss. But these claims will now be able to proceed if Minota Friends' interpretation is accepted by the court, and that's part of what leads to experienced media judges such as Mr. Justice Tugendhat stating, and Mr. Justice Eadie, that being sued at all is a serious infringement of the right to freedom of expression. And this citation for that, there's a number of citations, but one can find that footnote 26 on page 13 of the skeleton argument, internal page 62. And of course, the court has its own interest in ensuring that there's a meaningful harm hurdle. It shouldn't waste its resources policing non-defamatory falsehoods, which may have caused no loss, irrespective of whether they've been published maliciously, or encourage claimants to, as it were, get round the raising of the bar in relation to defamation, and corporations who could sue, they could sue citizen journalists. It's got to apply universally without having a meaningful case in financial loss. And the current edition of Gatley already states that one of the tactical advantages of malicious falsehood is it doesn't have a serious harm requirement. So there's no obligation to prove serious loss. It's just some loss. Particularly onerous requirement in my respectful submission. I'd like to move on to the three cases of this court, which in my respectful submission are binding as to the, I would say, requirement of the court to take into account probative facts in relation to financial loss, extraneous to the words, whether they occurred before or after publication of those words in the Section 3.1 assessment. And the first of those cases is, I think I'll take them in perhaps chronological order. The first of those cases is Sallows and Griffiths, which is at tab 9 of Unbridge 1. This was a case where the plaintiff and the first defendants were the directors of the company, and the second defendant was the shareholder. The defendant sought to procure the plaintiff's removal by making trumped-up charges of dishonesty in relation to his conduct as a director, which were communicated to him at a board meeting. Just pausing there, look at those words in isolation. You've been dishonest as a director. In the abstract, that might tend to make people not want to appoint him as a director. The malicious falsehood claim is based on publication to the solicitor for the company at the board meeting and to the company. And a further alleged publication was made to the personal assistant of one of the defendants. There was a separate claim against the company for wrongful dismissal, which was settled with the payment of damages. The judge awarded £5,000 damages for malicious falsehood. The defendants appealed on the basis that neither the solicitor nor the personal assistant could cause loss to the plaintiff, and there was no separate publication to the company, or if there was, any loss was indistinguishable from the loss for wrongful dismissal. So just pausing there, this double compensation point only would apply to the publication to the company. One has to look at the publication to the solicitor and the publication to the personal assistant. And the Court of Appeal accepted the defendant's submissions, which were, let's say, neither the solicitor nor the personal assistant could cause loss to the plaintiff, and allowed the appeal. And its essential reasoning is evident from the passage at paragraph 17 on page 107, which was relied on by the judge at paragraph 205. And this passage is also reproduced in the headnote. Headnote 7, there's an error in my skeleton. I put headnote 1, but it's headnote 7. If I can simply invite you to read paragraph 17.
Thank you. Required to consider the circumstances of publication in determining whether consequential financial loss is likely. And if those circumstances provide no evidence of likely loss, the claim will fail. You have to go beyond the words into the circumstances of publication. So going back to the statute itself, that's where we can add if the publication of the words. You're required to do that, and that's fine in the Court of Appeal authority in my respect to submissions. It's the publication of the words that's supposed to be likely to cause loss. That's the first step in my submissions, and in this case it would be fatal for the claim if you stepped outside the words, because the circumstances of publication and the judge's finding clearly there is no financial loss, either likely or had been caused. Likely at the date of publication or had been caused in fact. And insofar as I need to deal with it, it's clear what the ratio is. It's not per incuriam. There's a citation of Kay and Robertson. It's not argued it's per incuriam, but there's a citation from Kay and Robertson, which is a Court of Appeal decision, which is quite an interesting one, a quia-timet injunction involving Section 3.1, giving an illustration how Section 3.1 can be used in relation to quia-timet injunctions. And the point has, at the very least, been considered by the court. It's a statement of legal principle essential to the decision on the case on malicious falsehood and considered. The next judgment is, which I submitted binding on the court and deals directly with the points in issue on this appeal in relation to interpretation, is Tesla and BBC, which can be found at tab 23. This was an application
to amend the particulars of the claim. The claimant, now well-known manufacturers of electric cars, and the broadcast was a Top Kid broadcast. Permission to amend was refused on the grounds that the case on special damages and Section 3.1 did not have a real prospect of success. That is one ground, clearly the basis of the court's decision. The alternative was, if it did not pass the Jamil threshold. I'm going to go through the case to make good these points, but they're all referenced in my skeleton argument of paragraphs 7 to 15. The programme contained a number of criticisms of the performance of an electric car that, viewed in isolation, would clearly have put off a potential purchaser. So would satisfy any form of tendency test, just look at the words. The reason that the Section 3.1 case did not have a real prospect of success was that the programme had been broadcast on numerous previous occasions outside the limitation period by the time of the broadcast complained of. That's an extraneous fact, clearly relevant to causation, and it was therefore likely that any loss arising from its contents would already have been caused. Therefore, no case on Section 3.1. Alternatively, if there was any loss, not substantial enough. So,
they're all pre-publication.
Pre-publication. The next one, Tinkler, is post-publication. But this is.
In both cases you just showed us. Swallows was pre-publication as well.
If I can perhaps put it another way, there was no post-publication probative fact or causation that was
publication to these three people.
Yeah, bearing in mind
would be unlikely. Bearing in mind who they were
in the circumstances. Yeah. So accepted. Not in my submission. Authority, at least for a forward-looking test from publication on the basis of what's already in existence, but not necessarily authority for historic test, which is what the judge applied a historic test in this case, in the present case before the court. So the problem for the claimant here was the huge amount of broadcasts, each of which would be technically a separate publication than malicious falsehood terms which had taken place before the publications on which they complained. In addition to that, at first instance, Mr. Justice Tugendhat, and the reference for that first instance decision is 12352.
So when you say 12352, what's that?
Sorry, there's actually two first instance decisions.
Well, don't worry, I just didn't understand the reference. Is that page 352 of the bundle?
That's tab 1, sorry, bundle 1, tab 20, page 352.
Okay.
And there's also tab 22, page 404.
Okay, which is the one you want us to go to?
Well, I'm just giving you the narrative. I'm going to go to. I'm just giving you the overall summary, and I'm going to make good my points by referencing particular provisions of the paragraphs of the judgment. So, at first instance, Mr. Justice Tugendhat had also found that in relation to each false statement complained of in the programme, there was a true statement not complained of relating to the same subject matter, which was unfavourable, and that this cancelled out any likely loss from the false statements. So that's that's an extraneous factor for two reasons. Firstly, because those are not the words on which the action is founded, because the claimant wasn't complaining about them. But even if you stretch the words on which the action was founded to include the non-complained of sections within the programme, it would still be an extraneous fact because it was the truth of the non-complained of programmes. If you just looked at the non-complained of bits in isolation, that's another bit of unfavourability which would have caused financial loss. So if you didn't look at truth or falsity, that would be neutral, potentially, in terms of causation in relation to Section 3.1. But the relevant factor was that these statements were true, and therefore, these statements were true, and therefore they would put off a potential purchaser, so you couldn't attribute the loss to the falsehood, which you've got to do, which is falsehood. You've got to attribute the specific loss to the specific falsehood, or the general loss to the specific falsehood. So while the Court of Appeal disagreed on the facts, it didn't question that in principle such an argument was available to a defendant. The other important aspect of Tesla is it's very clear on the distinction between special damage and general damages in terms of Section 3.1. With that, can I take you to the judgment and just highlight the relevant parts? The introductory paragraphs explain the programme and the parts that were complained of and the parts that were true. I mean, essentially, it's to do with the main thing was how long the battery lasted when given a right turn over by the Top Gear team on their track.
So I've lost which of the Tesla decisions are we
Court of Appeal model, sorry, it's tab 23.
Sorry, are we looking at any particular?
Well, I'm just going to flag up the reasonable, the relevant parts of it. You can just see at paragraph 10, the application of the BBC was that the particular claim disclosed no reasonable grounds for bringing them or was an abusive process, just to identify what was in issue.
They were also seeking summary judgment. Does that matter?
No, because the key issue is the validity of the viability of the Section 3.1 case in the light of the previous broadcasts. And they then amended a further draft amendment. You can see in 13 to add a claim in special damages. See that from 13.3 at the bottom. And then the judge identifies problems of causation. First one being the previous broadcast, the second to do with the range. And then in that final sentence, moreover, as he later pointed out, in relation to the claim for malicious falsehood, the question of causation.
Sorry, I got lost. Where are we?
We're at paragraph 14.
Paragraph
last
14.
sentence, it's four up from the bottom.
Okay.
Moreover, as he later pointed out in relation to the claim for malicious falsehood, the question of causation was further complicated by the inclusion in the programme of understatements, favourable, etc. So causation is very much what the court is considering in relation to both Section 3.1 and also the newly introduced special damages claim. And then we can perhaps move to paragraph 27. Common ground, the claimant can recover general damage under Section 3 of the Defamation Act. You can prove that the statement which he complains is calculated, i.e. more likely than not, causing pecuniary damage. There is no appeal against the judge's decision in this case because of the problems of causation to which he referred. Tesla should be required to set out the nature of its case in some detail. So, in other words, that the problem of causation was primarily the previous broadcast that couldn't be sued on. So that was clearly in play in relation to Section 3.1. And continuing there, that was necessary to enable the BBC to understand the grounds on which Tesla alleged the statements on which he relied are more likely than not to cause it damage. I'm just highlighting the relevant passages. I don't believe I'm missing out anything relevant, but no doubt my learned friend will say if I am. I think we can then move to the bottom of paragraph 28, 4 lines from the bottom. It was also have regard to the intrinsic merits of the case which the applicant seeks to raise because it would clearly be contrary to the overriding objection to the commission to pursue a case which had no real prospect of success at trial. The latter is of some importance to the present. So clearly they're grappling with the merits of Section 3.1 in the light of causation problems. Paragraph 29 is a paragraph cited in the Friend's scope and argument, and it refers to the pleaded case, falling into 2 parts. The second sentence, paragraph 9.1 to 9.4 of the draft sets out the nature of the damage which is said each of the broadcasts was likely to cause and the reason why Tesla was more likely than not to suffer damage of that kind. Paragraph 9.5 on the other hand contains lengthy particulars of what are alleged to be the actual effects of the broadcast. That's after publication. This is the broadcast complained of. Strictly speaking, not particulars of probable consequences of the broadcast, but Mr. Spearman argued that would actually happen, provided some evidence of what was always likely to happen. So Maloney friend relies on that by suggesting in some way that the court has made some determination that future subsequent acts are admissible, but my submission, it doesn't make that point. It's simply an observation on the pleading as drafted by Mr. Spearman, and Mr. Spearman being the Deputy High Court Judge in this case, a practitioner of huge experience of defamation, or notable that I would have to accept. He doesn't explicitly say it's not necessary for me to consider all these other broadcasts, because it's quite clear that the wording of this broadcast is going to put off someone buying my client's car. He doesn't make that submission, which is the submission that's being put effectively by my learned friend before the court today. And so, moving on to 31, at the heart of the judge's concerns lay the question of causation. Following the original broadcast on 14 October 2008, there were 27 repeat showings of the programme for the earliest actionable broadcast. So there's every reason to think that the programme was capable of causing intensive damage, until possibly most of that damage must have already been caused by the time that statements complained of were published. It's also possible that earlier time bar broadcasts.
If you're reading large chunks, it's easier just to ask us to read them.
Yeah, well, I mean, again, it's a clearly causation past broadcast relevant. There's a section here relevant to the special damage, general damage distinction. It's 5 lines up from the bottom in the middle. Although for the purposes of a claim under Section 3, it was not necessary for Tesla to identify how much damage had been caused by the actual forces. It was for those reasons necessary. In this case, we described in general terms the nature and extent of the loss likely to result from the publications which were the subject of the action, and to grapple with clearly the causation problems caused by the previous broadcasts.
Well, is that what that's saying? I mean, as I understood what it's saying is, you don't have to, for the purposes of a Section 3 claim, plead specific damage,
Yes.
specific loss, i.e. draw the direct causal link between the statement, publication of the statement, and a financial loss. That's the direct link that Section 3 is designed to say you don't have to do where you have a malicious falsehood. You can simply say by their words in the context in which they are uttered to the people that they're uttered to, they are likely, more likely than not, calculated to cause financial loss.
Yes, but it's got to be a link between publication and financial loss.
Well,
but it's direct. I mean,
But it doesn't have to be direct, because that would, if you could plead it as a direct link, you'd be pleading specific.
Yeah.
But you have to identify what type of loss and why you say that type of loss is in some way likely to result from the publication.
Yeah.
In general terms,
yes.
you know, sort of
result from the publication.
Yeah.
Consequent, and that's perhaps that's not the best passage to take you to, but it's
that's a pleading point.
yeah. I mean, it's perhaps best stated at paragraph 37, about 9 lines down. Since the sentence starting, since the claim is for general damages, it is unnecessary for the claim to identify the amount of pecuniary loss. So no quantification needed, which you said the forces were calculated to cause. All is required in order to make the nature of its case clear is identification of the nature of the loss and the mechanism by which it is likely to be sustained. And then in the ordinary course of things, derogatory statements about commercial products are likely to put off some potential customer the consequent loss of revenue from sales, etc. And yeah, although the overall effect of statements, just continuing there, although the overall effect of statements conveyed has to be judged in the context of a number of statements, I can see that the court might find it likely that some potential customers would be deterred from buying erosive by the actionable statements if they would not be deterred by any of the non-actionable statements. So there has to be a causation link, and you can, if you wish, make it as a claimant faced with a widespread publication to your customers, say, well, this is an allegation which would tend to put customers off my product, and I infer that that has happened. And absent any opposing causation or competing cause being advanced by the defendant, as it was in this case, no doubt you will have a fair chance of getting home on Section 3.1. I would submit, if necessary, that in the modern era, actually proving special damages is not that hard, because there is so much documentary records of things, emails, communications, messages on customer review sites, etc. It's actually measuring things is much easier. But in any event, Section 3.1, consistent with the interpretation for which I'm contending, you're perfectly entitled as the claimant to draw that inference on the basis of the extent of publication and the nature of the allegations when it's to a large group of people. But the key point here is it's just the two people, and there are precise findings which are not challenged that those publications did not cause any loss. And it's obvious that as a date of publication, the publication to those two people in the circumstances in which they were published would not cause any loss if we're looking at a forward-looking test. So it's really just a question of level of particularization. It's nothing more than that. That's how far do you have to go in quantifying your loss in order to rely on it as special damages? Well, maybe that's now academic, because you can rely on Section 3.1, where the court thinks it's more probable than not that some loss has been caused, even if you can't pin it down. It's paragraph 37 where the possibility of Jamil abuse of process is raised on the basis that even if there was some loss, it would be minimal. Then the judge deals with the claim for special damages. His conclusion is at paragraph, their conclusion, the court's conclusion is at paragraph 45. In my view, the case pleaded in support of the claim for special damages say very similar to the same terms. In addition, it sums from a more fundamental problem to which I've already referred in the context of the claim for general damages, linking the two, namely the difficulty of showing the extent to which any loss that can be established is caused by the actionable statements rather than statements that for one reason or another are not actionable. This is a particularly acute question, etc. So the judge cited paragraph 45, which deals with special damages, and is criticised for it, but he also cites the passage which makes clear that these acute causation problems are equally relevant to the claim for general damages under Section 3.1. That's paragraph 47. So he accepts that it's adequately pleaded. That's the first sentence of 47. However, this is now 5 lines down, 47. This is a case where there are grave difficulties in identifying any pecuniary loss that the actual false statements were calculated to cause. And then Lord Justice Morbick invokes the Jamil jurisdiction, but it's clearly in addition to the substantive point in relation to liability on Section 3.1. And then his conclusion is paragraph 49, and it's really starts in the last 2 paragraphs, starting 4 lines from the bottom. It follows that I'm not persuaded that the case which Tesla seeks to make by the proposed amendment has any real prospect of success, number 1, or if successful, it's likely to yield any benefit to Tesla and can justify the devotion of substantial resources in terms of cost and the use of court time its determination would require. Judge therefore right to refuse permission, and then confirming that in paragraph 50, 4 lines from the bottom. Accordingly, if I was satisfied the claim had a real prospect of success, I would not refuse permission to amend on that ground. So this, in my submission, as a general proposition, this case is authority for the fact that any probative fact in relation to causation of likely loss is admissible it's not just a question of whether the defendant can raise a case based on the words. It's open to the defendant to rebut that case by relevant competing causation factors that at the very least exist at the date of publication. We can come on to the next case, which deals with factors occurring after publication, which were relied on by this court in reaching an equivalent conclusion on the facts of that case, which was that it had no real prospect of succession in relation to section 3.1. That case is Tinkler and Ferguson, which is in the second authorities bundle. 31. This is an appeal from the judgment of Mr. Justice Nickling, now the head judge in the Media and Communications list. The publication in Tinkler, and I'm going to just give a summary of the case and then I'll go to the relevant passages. The publication in Tinkler was an announcement to the stock exchange, which was critical of the claimant's management, clearly impacting on him if he did statement in isolation. Could be said that it would put off other people having him as a director because he's been very disruptive in relation to the management of this publicly listed company. And part of Mr. Justice Nickling's reasoning, which I'll come to specifically, was that if the announcement was the only thing that had affected Mr. Tinkler, the only public statement at that time, then an inferential case based on a drop-off of other directorships or investment opportunities might have had some prospect of success. However, it was only one incident in a wider battle played out in public, with other previous and subsequent publications more likely to cause him financial loss. Therefore, no real prospect of success in relation to Section 3. Court of Appeals key question was, is there an arguable case that the losses, financial losses, were caused by the publication of the announcement? That's the key question the court was addressing. Were the losses caused by the publication of the announcement? Answer, no. No prospect of success on that because of pre-existing and subsequent competing causes. Therefore, Section 3.1 case, not viable. Essential part of the reasoning you can take into account post-publication facts. Now, the relevant passages. I'm going to start with the head note. At the bottom, there's a line indicating passage from the head note. Limited force of action was rightly struck out on an additional basis. It did not disclose a reasonable course of action. The claimant had not in any event satisfied the requirements of Section 3.1 of the Defamation Act. Just pausing there, the previous reason was that it was a relitigation of a subsequent litigation involving the claimant and the company. But that doesn't detract from the fact that this was also an essential part of the court's reasoning as to why the claim should be struck out. I'm just trying to point to the relevant factual matters as quickly as possible. Paragraph 2, you can see it's the judgment of Lord Justice Peter Jackson. You can see that it's recorded the judge struck out the claim because Mr. Tinkler did not have a proper arguable case in the court proceeding damages as required by Section 3.1 of the Defamation Act. And then just relevant facts are set out from paragraph 4. Most relevant are that he was dismissed as a director on the 14th of June 2018. You can see that in the penultimate and final line of paragraph 4. Then there was an announcement to the London Stock Exchange. That was on the 29th of May 2018. That's the one that was complained of. But if you can see from paragraph 5, it followed an earlier announcement on the 25th of May 2018. Then the next thing that occurs is the judgment of Judge Russin, Queen's Counsel, yes, that took place on the 15th of February 2019. You can see that from paragraph 2, and it's summarised in paragraph 7. Key finding is that this is about 8 lines down in paragraph 7. He'd acted in serious breach of his fiduciary and contractual duties, and his dismissal as an employer and removal as a director had been lawful. And then paragraph 24 recites the judge's findings, including the real problems faced by Mr. Tinkler in relation to causation. That's the first paragraph cited in paragraph 24 of the Court of Appeal's judgment, and paragraph 95 of Mr. Justice Nickling's judgment, and then the key part of the judgment of Mr. Justice Nickling, on which I rely, is from 94.3, which is set out. Perhaps I could just invite you to read that. It's making clear the causation factors that the court took into account. It's paragraph 24 of the Court of Appeal judgment, citing paragraph 94.3. Nickling.
Yes.
This is all in relation to a case on section 3.1, I emphasise, not special damages. And then on paragraph 39, you can see the grounds of appeal. It's at paragraph 6, that's the one that relates to section 3.1 and damages. And then the statement of, sorry, I should have, if you can just turn back on the page, 36 to 38, the court states the relevant legal principles, nothing very uncontroversial there. It's relying on Tesla, 36 and 37. And the word used there is to cause pecuniary damage, calculated to cause pecuniary damage. And then the case on appeal is recited in paragraphs 55 to 57. Paragraph 55, counsel for Mr. Tinkler says that the right to general damage not cut down by later events. And then there's a reference to damage to reputation in paragraph 56. And then in paragraph 57, there's a case brought on the basis apparently that Mr. Tinkler wanted to sell his shares at the time of the announcement, and then the announcement caused a drop in the share value, and then that affected his ability to sell his shares. So that's the case as it was put, and the conclusions of Lord Justice Jackson, with which the other members of the panel agreed, are set out at paragraphs 76 to 83. And there's a subheading there, Section 3 of the Defamation Act 1952. This issue gives rise to two questions. First, are the sorts of losses claimed by Mr. Tinkler recoverable in principle? That's not an issue with which we're concerned in this case, and that was dealing with the damage to loss of reputation and the effect on the share value. But the next question is clearly relevant. Is there an arguable case that the losses, were caused by the publication of the beyond these questions, like the further issue of whether the value of the claim is likely to justify continued litigation. That's a reference to Jamil, which is often brought in to accompany such submissions on behalf of a defendant. And then perhaps we can move to 81 through to 83, and because they're significant, can I just ask the court simply just to read 81 to 83, please?
Yes. Yes.
I rely on Tinkler for the submission that all relevant probative considerations and financial loss are in play in the Section 3.1 evaluation as to whether financial loss has been caused. This authority requires suggesting that the court is looking back from the date of the court's determination of Section 3.1 as to whether there is a real prospect of showing that financial loss has been caused by the publication complained of. Mr. Justice Nicklin thought that if the publication complained of was in isolation the only thing that mattered, there could be a proper case to be made. But there's all these competing causation factors which are, on the Court of Appeal's reasoning, required to be taken into account. And if they lead to the conclusion that there is no real prospect of showing that financial loss has been caused, the claim under Section 3.1 must fail. Similarly, it must follow from that if at trial it is proved that no financial loss has been caused, Section 3.1 claim must fail at trial.
What was Lord Justice Peter Jackson's reasoning based on there being technically no cause of action, or on what I might loosely call Jamil?
It's based on Section 3. You can see that from you can see it from the head note. You can see it from that passage, which is conclusion on reasonable cause of action, Section 3 of the Defamation Act, just above paragraph 76.
Well, I don't think we need to worry about the head note, because the head note may not be right, but
it's probably 86 probably puts it as crisply as anything.
Yes, but the additional, the first one it's not the Jamil abuse of process, it's the re-litigation abuse of process. Not a Jamil point here. The first point is because of the judgment of, I think in order to establish falsity, the claimant inevitably had to challenge findings of fact that had been made by Judge Russell. So that's not a Jamil point, that's a re-litigation point. And then there was an independent alternative ground, which in my submission still has precedent value. Because
the judge struck out the case on failure to satisfy 3.1.
Yes, in addition to the re-litigation. The judge, yes. I can take you to the first instance judgment. It's clear from Court of Appeal's recitation of what happened in the first instance. Yes, the judge. Mr. Justice Nicklin is quite clearly in favour of historic test. He's referred. You can see it in subsequent decisions of his. At the moment, I'm just focusing on the ones which I respectfully submit have binding on this court. But there's plenty of other authorities that support the admission of relevant facts beyond the words, probative on absence of financial loss.
Yes, thank you.
So I was now just proposing to whiz through the other authorities which I put in my skeleton argument are inconsistent with the tendency test. Perhaps I should rephrase that as being consistent with the admissibility of the material which the judge relied on in the first instance in the present case in order to find that the Section 3 case failed. The first one of those is IBM and WebSphere. I refer to it in the context of the Article 10 point on calculating it's a decision of Mr. Justice.
Sorry, can we just pause just for one moment? I just want to think this through. Okay, I don't think I need to put anything to you. Thanks.
Just so I understand where at some point we're going. When you started your submissions this afternoon, you mentioned the two publications.
Yeah.
One Butler, the other one to the gentleman whose name I've suddenly just
Lingenfelder.
Lingenfelder. You sketched the Butler point. Did I miss you sketch the facts in relation to the Lingenfelder?
Oh, if I did, forgive me, but the relevant facts in relation to Lingenfelder are fairly brief. And they're set out in the respondent's notice, which might be the best place to look at them. So the respondent's notice is on the basis that the court is going to adopt a forward-looking from publication test. It sets out the relevant facts. And the respondent's notice is at tab 22, and the relevant section has been extracted so that you can read it more easily. Page 22 of the bundle.
Page 22.
And when I make these submissions, it's necessary to bear in mind that for malicious falsehood, whether it's special damages or Section 3.1, the damage, at whatever level of that, financial loss at whatever level, has to be consequent on the falsehood. So paragraph C deals with the Lingenfelder email, which was sent at 4:37 in the afternoon, and the timing is relevant. Because on the forward-looking test, that's when you stop the analysis of relevant facts. So the starting fact is that Mr. Lingenfelder had never wanted the claimant to deal with the second defendant's clients and warned her against doing so.
But she had.
Yes, in breach of her assurance to the defendants that she wouldn't, and in breach of what Mr. Lingenfelder had told her. That's the finding of I mean, I really don't want to relitigate.
But she was entitled to.
But he was her boss, and he told her not to. He didn't want her to.
She didn't cover that.
But, okay, well,
I mean, it's just, so, okay, it's probably not the place, but when we're looking at this very fine distinctions between, on the historic test, what happened before, what happened after, the causation questions. As I understand it, although her new boss had said, don't deal with these clients you previously dealt with, she did.
Yeah.
And she was, in fact, not prohibited from doing so, so would have been entitled to earn commission on it.
well, let me just take it. So the judge's finding was that her employer had told her not to, didn't want her to. But there's another more relevant prohibitive
what he actually found in those paragraphs you just referred us to, 92, 93, was that, yes, indeed, Mr. Lingenfelder said, don't deal with clients you previously dealt with at LCA, but that fell on deaf ears.
Okay, well, let's leave it at that. Falling on my submission, the instruction not to deal with the second defendant's clients is by Mr. Lingenfelder is relevant when one comes onto the likely reaction of Mr. Lingenfelder when being told truthfully that the claimant is dealing with the defendant's clients, and whether that might be the cause of his instruction to her not to do so in the future if that's the basis of the loss. It's not the fact that there's a restrictive.
The reason I asked you is because, I mean, you said very clearly, well, Mr. Butler would never have dealt with the claimant anyway, and that was the evidence, that was the finding.
Yeah.
So
he's straightforward.
but this is a much more difficult factual issue to fit into the
It might
forward-looking, historic-looking.
There's another fact that we're coming to, which is
Right, okay.
extremely
Right.
powerful. And
So
that's,
I was just trying to readjust myself to the,
Yeah.
after all the citation of the authority.
I
was just
understand.
trying to readjust myself to the
Well,
facts
I mean,
we're looking at.
I think the starting point, if I may respectfully submit, is one of these facts relevant to the likelihood of the sending of the email to Mr. Lingerfield accusing claim of breaching restrictive covenant? Is that relevant to whether that falsehood is going to cause loss? That's the key question.
As I understand it, the claimant's case was she was entitled to deal with the client she'd previously dealt with at LCA. There was no contractual restraint to prevent her from doing so, even though Mr. Lingenfelder might have told her that she shouldn't. She did. She would earn commission on it. But what caused her the problem was the additional malicious falsehood that she was contractually prohibited from doing so.
I have a killer point on that, but I do.
Okay,
Since
You had
my lord is addressing this, I feel I have to deal with it. I was feeling that I had the judge's findings of facts in the bag, so I didn't have to worry about this. But I think the chronology was, and I didn't appear at first instance, was that it was the first defendant, who assisted the claimant to get the job with Mr. Lingenfelder, I believe. And Mr. Lingenfelder, knows, having a business in another area of recruitment, didn't want to, as it were, step on the toes of the defendant. That was, and also that the claimant had given an assurance to the defendant that she wasn't going to do that.
Okay.
But it's certainly the case that she only got the job because the first defendant got in touch with Mr. Lingerfield and asked if he wanted to take it.
No, that's not correct. The first defendant gave a reference for the job to Mr. Lingenfelder.
Well, in any event, the finding of fact was that Mr. Lingerfield didn't want the claimant to deal with the second defendant's clients. The finding of fact was that the claimant had given an assurance to the first defendant that she wouldn't do so. That's the first fact. The next fact is the George email, as it is called. So this was sent at 16:30, so it's 7 minutes before the Lingerfelder email. It's sent to the claimant by the first defendant, in which she states that she will be writing to your employer, advising them of your actions and seeking their assurances that they will prevent you of using your post-employment restrictions. So she's actually telling the claimant what she's going to do. At this point, and this is a pre-existing fact, the claimant had the handbook in her possession at that time, which demonstrated that there was no post-employment restriction against dealing with the second defendant's clients. So she then goes in the direction immediately of Mr. Lingerfeld. What we don't know is exactly what time she got there, but obviously, wherever you freeze the frame, clearly that's what she was going to do, having the handbook in her possession, knowing that the first defendant was going to write to Mr. Lingerfeld. She goes to him with the handbook, and looking at 3.4 of the respondent's notice, she goes to see him, and then what happens? That's a paragraph 5. She shows him the handbook, so he can see for himself that there's nothing preventing me speaking to Balgores or Strettons or any other LCA clients. And Mr. Lingerfield accepted that this was the case, because it was obvious in the handbook there was no restriction. So the falsehood is not even if one accepts it, putting to one side the fact that he never wanted to deal with the second defendant's clients, just the falsehood of itself could not have been the cause of anything, because he could see it was untrue. He didn't believe it. And even if one freezes the frame before the claimant arrives with the handbook, that's obviously likely what's going to happen.
Well,
sorry.
I'm struggling with the handbook one. It was uncertain. It was unknown at the time whether the claimant had the handbook in her possession. And 3.3 makes an assumption that she would do what she in fact did. Your client didn't know that she had the handbook in his
No, it's an objective test.
Well,
Section 3.1, it's not what my client believed. It's an objective test. The only question is not, did she have the handbook? That's the relevant fact. She had the handbook. That's the relevant fact for Section 3.1.
So you're saying that if the claimant in a case has the means to disprove a malicious falsehood, then a claim in malicious falsehood never gets off the ground.
Absolutely. I mean, this is a very limited publication. I mean, you look at Joyce and Sepgupta, it's an article in a national newspaper accusing a royal lady's maid of dishonesty. If you look at Codabricks, these are circulations going throughout the Iranian community suggesting that the claimant is a prostitute. I mean, this is a very specific situation here. There may well be specific situations where it's possible very quickly for the claimant to demonstrate that the allegation is false. And that's partly why I referred to the Stuart Brady case and the Must decision, which I referred to, which relied on Brady in my note. I mean, it's no more than stating the obvious. If you're entitled, in order to establish liability for malicious falsehood, you have to show that it's going to be reasonable, assuming it's a forward-looking test, it's going to be reasonable that the publishee is going to act on this information without even raising it. And in the circumstances of Must, it clearly wasn't reasonable for the publishee. This was a case about an investor who's told a company is a dud. And Mr. Justice Freeman, one of the grounds on which he rejects the malicious falsehood claim is that it was likely that the publishee would go to the company before he did anything, and then the company would be able to demonstrate that the allegation was untrue. This is a stronger case in terms of rebuttal of a Section 3.1 case, even if the test is forward-looking, because here the claimant was on her way to see the publishee with the means of demonstrating that the falsehood was false. And the judge's finding was that it was obvious from the handbook that there was no restriction. Mr. Lingenfelder could see that for himself. So even if Mr. Lingenfelder really wanted the claimant to deal with the second defendant's clients, any decision following publication of the Lingenfelder email for her not to do so, to instruct him not to do so, could not be based on the falsehood. It may be that he wanted to keep good relations with the first defendant, or for any manner of reasons, but the loss has to be consequent on the falsehood. And if the claimant is in a position to demonstrate that it is false, and there's only one publishee. So at the moment, let's forget about Butler, because these require separate analysis. Lingenfelder is a discrete publication. Claimant's able to show Butler is untrue. Then no cause of action, because I come back to the basic point that this is an economic tort. It's concerned with likely financial loss. And there are plenty of other ways in which speech can be restricted, but it's quite clear from the authorities that we've seen that, at the very least, on a forward-looking test, it has to be likely at the date of publication that the words are going to cause some financial loss. And the suggestion here, although it wasn't pleaded as a mechanism, was that it would lead the falsehood would lead Mr. Lingenfelder to tell the claimant not to work with LCA clients, or try and poach LCA clients. And he didn't want her to do that anyway. He told her not to do that. So the falsehood couldn't be the cause of that. And anyway, it was demonstrated that the allegation was false. So again, the falsehood couldn't be the cause of it. So if we adopt the historic text, just since we're on the facts here, it's quite clear there was no financial loss consequent on the falsehood, because on the judge's findings, paragraph 5, he accepted that there was no contractual restriction, so therefore no loss. That's not challenged, not capable of challenge. There was no financial loss arising from the Lingenfelder publication. Lingenfelder received it, that what actually happened was the overwhelmingly likely consequence. I think I probably, given my Lord's questions, I think I probably do need to refer briefly to Stuart Brady and express.
My question is driven by the fact I probably wasn't as clearly on top of what you say the chronology as you set it out in the respondent's notice when listening to the submissions. So don't do it just for me.
The key point is, I think it's accepted that the loss, financial loss in whatever level of probability, or however it's future or likely, has to be consequent on the falsehood. And if the publishee doesn't believe it for whatever reason, it can't be the cause of the loss. There's a case cited in Gatley which makes this very fine distinction, where part of a statement was clearly a malicious falsehood, which had the potential to cause loss, but another part of it was true, and it was the true part of it that caused the publishee to act in the manner that he did.
In that situation, it doesn't really matter, does it, whether the other part is true or not? If it's not complained of, or not proved to be false and malicious, it's another causal factor.
Yeah.
Whether it's true or not.
Yes. And the specific falsehood pleading as being the cause of the loss in the particulars of claim is the full statement that she had been, I think it's a full statement that she had a restrictive covenant. We probably ought to just look at see how it's pleaded. It's in the same bundle. It's at tab 11. Paragraph 17 at the bottom of page 165.
Sorry, where are we now?
It's tab 11 of bundle. Sorry, tab 11. Yes, tab 11 of bundle 1, page 165, paragraph 17 of the particulars of claim, which identifies the falsehood complained of, falsehoods complained. So it's the existence of the clause and the breaching of it. Falsehood is not complained of that she was contacting the second defendant's client. So as soon as Mr. Lingenfelder knows that the falsehood is false, there's no prospect of financial loss arising from the falsehood. And even, let's supposing there'd be nothing prior about the instruction. Don't want you to deal with the second defendant's clients. If in response to that email he turned around and said, well, I accept you haven't got a contract. I expect there's no restriction. You can do what you want, but I don't want to have a run-in with the defendants. I don't deal with clients. Then that would not be proper causation. But in any event, we've got the prior situation where he didn't want to deal with them in any event and give them an instruction not to do so. And we haven't even factored in the relevance of the falsity of the assurance that she wouldn't be dealing with them. So the relevance of the true statement that she said she wouldn't be dealing with. But in any event, we don't have to re-explore the facts in this case, because the appeal is based solely on a common statutory interpretation.
The objectivity of the test, more likely than not. I mean, we've worked on the common assumption that it is an objective test. It's a curious one, this, isn't it? Because you're saying objectively, i.e., to an all-knowing observer, this wouldn't be very unlikely to cause financial loss to the claimant. But subjectively, the maker of the statement thought it would, because otherwise what's the point? Well, in fact, the findings were that they thought it would, because they didn't think that the claimant had the handbook and wouldn't be clever enough to show it to her boss. And that's the sort of converse of the normal situation, isn't it?
Well,
The normal situation is that it says you don't have to prove that somebody intended, because you can rely on the fact it's just objectively more likely than not. Here you've got the converse. The objective person actually knows it isn't going to have the result that the subjective person thinks it is.
yeah. Well, it's not just malice is insufficient. There is a damage hurdle, of whatever kind. You could say if you publish a falsehood maliciously, there should be a remedy, but that's not the law. There is a damage hurdle, and so the subjective questions get dealt with at the malice stage and can be held against the defendant. That's just one step in the process. There is this objective hurdle, and always has been.
But the reason that the hurdle is set as an objective hurdle is to stop somebody saying you can't prove that I did it intending to cause financial loss.
The reason there's an objective hurdle, I would submit, is because initially the courts didn't want traders to be having bargains about their products where there'd be no loss suffered. The reason why there's an objective hurdle now is in the modern human rights era, infringements into Article 10 have to be justified objectively with the existence of a sufficiently serious infringement of a claimant's rights, and also the court wants to steward its own resources, so it's looking to whether objectively loss has been caused or is likely to be caused, and that test is binding authority on the court. It's an objective test, and it's not. I think.
No, I'm just trying to flesh out what objective actually really means. Objective just means normally you don't look at the subjective state of mind of the person making the statement.
It's the tortfeasor. You don't look at in the Section 3 equation. The tortfeasor is irrelevant, the defendant, but the publishee. What he knows is an objective fact. Your Lordship, my Lord Justice Snowden referred to an all-knowing publishee. One doesn't impute knowledge to the publishee, which the publishee doesn't have.
No, it's an all-knowing observer, in fact, because the publishee didn't know about the handbook either.
No, but the publishee was about to know about the handbook. It was inevitable the publishee was going to know about the handbook. The objective facts are that the claimant had the handbook. She was in the same office as the defendant, as Mr. Lingenfelder, and the first defendant said she was going to tell Mr. Lingenfelder. So that's why that's why there was never going to be any loss. And maybe that scenario is very well illustrated by the Stuart Brady case and the Musk case, where the publishee acquires knowledge after the date of publication, but it was always likely, on the balance of probabilities, that the publishee would obtain that knowledge. And if that was likely at the date of publication, and that knowledge would preclude any finding of financial loss, then the Section 3.1 claim fails, because it's an objective test based on more likely than not, which takes into account any probative fact on causation, and certainly any probative fact in existence at the date of publication.
So on this approach, one of the problems I've got with this is trying to work out how practical and effective it is. I think on this approach, a claimant has got to go out there, in a typical case where their professional or business conduct has been disparaged to third parties who they have an interest in dealing with. They've got to go out and explore in detail what all those people would have done if they hadn't been targeted by this statement, and whether they would have continued or not continued to do business. So in this case, the claimant, before she started her action, would have had to go out and find out what eventually turned out to be the case in relation to Mr. Butler and Mr. Lingenfelder.
Well, with respect, no, because the distinction can be drawn between fairly widespread publications where you can rely on inference and very narrow publications where there's only a small number of publishers and you can find out.
Well, that's rather difficult, isn't it? Suppose there were 23 of them, and they were all inherently likely to take an adverse view as a result of the publication. But you don't know whether they did or didn't. Perhaps someone else had been going around bad-mouthing the claimant in a different way, which would have been sufficient.
Well, you could invite an inference from 23 people.
Sorry, you're muttering again.
You could invite an inference from 23 people, And in addition, I repeat the point that I've made before, that there are far more documentary records of communications having been made now.
But we're talking about a 1948 report and a 1952 statute, and it's difficult to feed that in, even if it's correct, which there is no evidence.
But the mischief is not quite the same as it was, because it's easier to prove.
The meaning can't change.
Well, it can change in relation to the Human Rights Act. The meaning doesn't change. It's always been, the meaning has always been that there has to be some financial loss of some kind. It doesn't just have to be proved to the level of special damages. It hasn't changed. But it could change on the basis of the Human Rights Act. That is a perfectly permissible statutory interpretation. It's not what Parliament was intending in 1952. It's what it's the position now. And the interpretive decision of the Supreme Court that my own friend took you to makes quite clear that that was a case that didn't involve any human rights or fundamental common law rights. Where Article 10 is engaged, you've got the duty, in fact, to interpret the statute in a way that may produce a result that parliamentarians in 1952 would find astounding. But there's nothing to suggest that parliamentarians in 1952 would have thought that it was creating a right to malicious falsehood, where you can prove that no harm has been caused. All the statements in the...
Well, I don't know. I would have thought that a conventional tort lawyer in 1952 would have had no difficulty with the concept of a tort where no harm has been... an action like a tort where no harm has been caused. There are plenty of examples of such things. All that happens is you only recover nominal damages, and if you only recover nominal damages, you may well be at risk to some costs. Very familiar situation.
It didn't make it actionable per se, which it could have done. It put in a requirement relating to pecuniary damage. And my respectful submission was that there was no evidence that Parliament was intending to create a right to sue in malicious falsehood where no financial loss has been caused. And I base that, on the statements in the Fawkes report, which refer to very serious damage which cannot be proved owing to the difficulties, and then the statements made by Lord Leader, which are plainly inadmissible as being unclear at the very least. But in any event, refer to the existence of damage. And that is not, in my respectful submission, what Parliament was intending to do. I mean, I'm not really very far through. I've got a whistle stop through because I'm going on to statutory interpretation.
Well, you better get on with it then. Yeah, because you've got to leave time for a reply.
Yeah. So other authorities inconsistent with the tendency test, just very quickly. IBM and
Well, it's up to you, of course. If they're not binding on us, do they really help?
Well, I suppose if the others are binding on you, then they're not necessary. But I mean,
Right.
I'm not asked. I mean,
It's up to you. You yourself were saying you were short of time. I was just wondering whether this was a useful use of your time.
very well. They're in my skeleton argument.
Yeah.
And also my skeleton arguments are just comment on Fielding and Variety and Quinton and Pearce, which were relied on by the appellant. I don't need to add to those. I deal with Calvert and Tompkins, which I submit is simply a case on pleading.
Yes.
And it's just a distinction between general and special damages. I make the point that Gatley clearly contemplates a historic test. I've set out the relevant passages. The passage in McGregor that we went to this morning, which talks about the need to, it's about financial loss having been proved. That's paragraph 4812, tab 2, sorry, bundle 2, tab 46, page 993. That's a very significant paragraph, and it cites Sallows and Griffiths. I've dealt with the modern approach to free speech and civil litigation. Important to have a look at a case on section 2 of the 1952 Act, which has the words calculated to disparage. Similar formula in terms of the is calculated to. And there's a decision of Mr. Justice Tugendhat, Andre and Price, it's cited in paragraph 49 of the My Skeleton argument, and that holds that you've got to look beyond the words complained of. You've got to look at the circumstances of the publication in order to assess whether the disparagement has in fact been sufficiently substantial. And you have to do that because of Article 10. It's another invocation of Article 10 to look at the reality of loss. You may think the phrase calculated to disparage is more tied to the words than the phrase calculated to cause financial loss, because financial loss is not something that really exists in the abstract, in the words. It exists in the circumstances of publication. So that Andre and Price decision will be at first instance by Mr. Justice Tugendhat, a judge with considerable experience in this area of the law, recognising there's necessary to be a threshold of seriousness in practice as to effect in order to reconcile.
Just remind me where that is in the authorities.
It's at Bundle 1, tab 19, page 335, and the relevant passage starts at paragraph 97 on page 349. Perhaps I will just, given the time, I'm going to go to it briefly. So it's an allegation to a studio audience that the claimant, Peter Andre, had had an affair with his manager, made by Mr. Andre's former wife, Katie Price. It was not broadcast. It was made to the studio audience on the Graham Norton show. And the issue was whether there was an arguable case that the words were calculated to disparage. And it starts at 97 and it just goes through to 103. Perhaps I'll just ask you to read those paragraphs. This decision got superseded in relation to what was meant by calculated in terms of more likely than
not. I've read from 97 to 99. How much more do you want us to read?
Probably paragraph 101.
Yeah, I'll read to the end. Yeah.
I've read it, except that Mr. Lingenfelder is a person with authority over the claimant. There's a reference to that, but of course, the facts in this case were that he was able to see that the allegation was untrue. So that's the end of that in relation to Mr. Lingenfelder. So just whizzing through statutory interpretation.
Yes.
The wording, I've partly dealt with it. Paragraph 51 of my skeleton argument. I start by submitting that the words upon which the action is founded naturally includes the circumstances of publication. This is a natural meaning, because without the instance of publication in this particular claim, absent that, there's no action. So it clearly includes the circumstances of publication. I make the point that there's never been any previous suggestion that Section 3.1 is directed exclusively to the publication of the words. You can't take out other probative factors.
Now, are you saying that, I haven't quite understood why you say it's necessary to Mr. Bennett's submissions that it's not directed to the publication of the words?
Because, as I understand it, he is submitting that as long as the publication, the words have a tendency, looks in isolation to cause financial loss, even if they haven't caused any financial loss and they're not likely to, you can still make good a case on Section 3.1.
Yes.
The facts of this case, this would mean that you couldn't take into account that Mr. Butler had already decided that he wasn't going to do business with the claimant.
Yeah, I've got all that point, but what's that got to do with whether or not they're published? Well, clearly, clearly it's about the publication of the words.
Yes, well, I think I think Mr. Bennett makes the point that there's no reference to publication.
Oh,
So-
I'm sorry. Well,
It's a
I
point made in
hadn't.
his skeleton.
Yes.
I'm not sure he's developed it on his feet.
No, I'm afraid I hadn't even picked it up.
Yeah. 53. I make the point that Parliament could have used the word tendency to cause financial loss, because that was the test that was being used in defamation, the tendency of the works. Didn't use that. 54. I make the point that it's. I think I've said this before, but it's fairly meaningless to say that words have a tendency or a propensity to cause financial loss, depends on the circumstances in which they're published. Sure, that's justifiable in defamation because it's an abstraction in the first place. You're judging it by reference to right-thinking members of society generally. Also, there's no single meaning rule in malicious falsehood, which gives rise to further complications if it's all about the meaning of the words. Those don't arise on this case because there was no dispute as to meaning, but if it's all about the word, you could go into real complexities if there's a dispute in relation to meaning. The next principle that I invoke is the avoidance of absurdity. It is absurd to say that words are calculated to cause financial loss when it's demonstrated that no loss has been caused. The judge makes that point, and I respectfully submit that it is a good point. I've dealt with the mischief. The mischief was to provide a remedy.
Why is it absurd? I haven't quite understood why it's absurd. Words published could be likely to have a financial impact,
but don't.
cause pecuniary loss, and then something unexpected happens. The person dies or gives up that business anyway, and then they don't. That's not absurd. It's just a consequence of likely not being the same as certain.
That's, I suppose, if you adopt a forward-looking test from publication. Perhaps those submissions are best made in the context of the Human Rights Act.
Yes, I see. Okay.
But yeah, that's just one point that I'm making. Settled practice. It's never been suggested that you ignore probative factors in relation to financial loss in interpreting section 3.1. And here we have a situation where Parliament has raised the bar to put a meaningful hurdle in relation to defamation. And it's inconceivable that it wouldn't have done so in relation to malicious falsehood if the interpretation contended for by the appellant had been operative. And then the Human Rights Act.
But there was nothing at all in the antecedents to the Defamation Act in which anyone suggested anything should be done at all about malicious falsehood or privacy or data protection or any of it. So I don't see how you can draw an inference from a failure to legislate.
Perhaps not, but I mean, their previous statutes have dealt with, the previous Defamation Acts have dealt with malicious falsehood.
Yes, they have. They didn't. So.
1996 Act.
The
1996 Act shortened the limitation period for both. And in my respectful submission, if the interpretation that had been is being contended for by the appellant had been accepted by the courts, all the free speech campaigners who were saying we need to have a meaningful harm hurdle to stop us being sued very easily by big corporations or whatever, slap litigation. We need to have the same thing in malicious falsehood. It's very easy for us to be sued, and it's going to be very difficult for us to strike it out on an absence of malice, and we're going to have to bear a huge amount of cost. So it may not be my best point, but I'm going to stick.
Find it easier to suppose that Parliament just didn't turn its mind to the question.
Yeah. And then I've got historical forward-looking. It ought to be historic. All the other tests are historic. The historic test prevents liability being imposed where there was clearly, demonstrably no loss. That would be unjust to a defendant where no loss has been caused. It would make a mockery, in my respectful submission, of the principle and taught that you're compensated for loss that you have suffered. And similarly, it would harm a claimant where there was an unlikely but foreseeable event that arose after publication which gave rise to loss. That on a test which freezes the frame at the date of publication only allows factors which are more likely than not at that time to come into the equation. And that would prevent the claimant from recovering loss even though loss had been suffered. It's got to work both ways, whether for the defendants and claimants, whether it's a date of publication or date of trial. And the fairer one is date of trial. It's also easier for the judge to actually assess, as at now, whether there has been any loss, and to go back to a previous period and assess whether loss was likely at that particular point, especially when you've got online publications that are continuing. And there's competing causation factors. And all the other harm-related determinations that tend to arise in these cases are historic. Whether serious harm to reputation has been caused under Section 1, that clearly you're entitled to take into account Mr. Lingenfeld's reaction post-publication, any post-publication fact. Financial loss under Section 1.2, corporation to corporations. Special damage, whether claiming defamation or malicious falsehood, that's a historic test, no question about that. Level of general damages, defamation and malicious falsehood, historic test, and the application of Jamil. All these are historic tests. There's no reason why a post-publication probative factor and causation should be admissible in relation to all of those, but not in relation to Section 3.1. And then I've dealt with the respondent's notice. If the claimant were to succeed on interpretation, there's no basis to go beyond nominal damages. It would be impermissible to go beyond nominal damages because the damages, putting injury to feelings on one side, have to be based on probable loss. And if there's no loss, it can't be anything more than nominal damages. You can't get injury to feelings because they have to be parasitic on loss. That's quite clear from Joyce and Sen-Gupta. In any event, on the facts, the injury that the claimant has suffered is relating to not the publications complained of, or alternatively a misunderstanding of the facts. In relation to Butler, she might have been upset about that, but Butler wasn't going to do business with her any longer. And the judge's finding it wasn't the publication to Lingenfelder that caused her the upset because the bosses were 100% behind her. It was the feared publication to all the clients of the second defendant, which the judge found did not take place. I've stressed the very limited nature of the publication here compared with the widespread publications in Joyce and Farast. So not available because there's no damage, and in any event, while there is evidence that she was upset by what happened generally, not in relation to anything that could be attributable to loss, or alternatively on a false basis. And then finally, no retrial on Jamil grounds. That's a point I'm entitled to invoke now because it's about what the court might do if it was to find for the claimant on liability. There's just no point in a retrial. Because
nobody's suggesting a retrial, they're suggesting assessment of damages.
Well, then it would have to be, yes, it would be 1p or nominal sum, and no damages for injury to feelings because there's no basis.
Well, that depends on all the other points.
Well,
I mean, I don't think you need Jamil, do you? I mean, if there is a reasonable prospect of more than nominal damages, given the situation we're in now, surely it must be right to have an assessment of what those damages are, or whether there are such damages.
Well, my primary submission is it's not open. It's not even a reasonable argument that there is anything.
No, well, I see that.
If your lordship is of course not with me on, I mean, having got to that stage, I've lost on liability. Your lordship think there's a real prospect of damages going beyond the nominal, which would have to be on the basis,
yeah, of course,
perhaps injury to feelings. There couldn't be anything else. Then I'm not going to win on my Jamil grounds,
That's rather what I thought.
Unless I could be any further.
No, thank you. I'm trying to ask you this point, which in fact wasn't made explicitly by Mr. Bennett in his oral submissions, but it's in his skeleton, I think. If there were to be an assessment of damages, he says it ought to be in front of another judge. What do you say about that?
Well, we're going to have we're going to have a complete re-hearing of the case.
Well, what is your submission? Is all I want to know.
Well,
do you say it's a good thing or a bad? Do you support that submission or oppose it? And if you oppose it, on what basis?
Well, I oppose anything that involves new findings of fact. I mean,
I'm assuming. Perhaps I should have followed this up with Mr. Bennett first. I'm assuming he would say the assessment would have to be on the basis of the findings and evidence already made. You couldn't have a whole new retrial on the question of quantum or the question of damages.
I mean, do you say there are things that the current the judge, Justice Stoney, would be uniquely positioned to bring to an assessment of damages, which another judge would not?
Yes.
And they are.
Well, he's heard the trial.
Yeah, but he also wrote a long judgment that another judge could read.
Yes. Well, I mean, I think I would submit that there can't be that any further trial in relation to damage on the assumption that we actually get to that stage. If it's based on the findings of fact by the trial judge, I don't think I can make any submissions in relation to whether it should be heard by the trial judge or any other judge. I mean, I don't think I've got any submissions that I can make.
But is it right, what Mr. I'm assuming it is, unless you tell me it isn't, that really the question of the quantum of any damages, if he succeeded on liability, she succeeded on liability, wasn't an issue in any of the submissions? Everyone just assumed that would be dealt with separately if she succeeded on liability. And then it all became complicated because of the post-draft judgment submissions. It's a bit unfair to ask you that because you weren't there. But
well, I mean, to get to that stage, you'll have to. I mean, obviously, I've lost on liability. You've rejected my submission that it has to be limited to nominal damages because, in fact, there wasn't any loss. It could include injury to feelings.
Without prejudice to Mr. Bennett's broader submissions, it's likely to be the focus is likely to be on injury to feelings.
I mean, why couldn't? I mean, well, there's a lot of points that would have been found against my client, big points of principle, but at that stage, which would have gone against my client, and I've got no idea what stance would be taken towards a retrial.
Did the trial involve cross-examination of the claimant about her written statement, where she explained her reaction to events?
Apparently it did. I mean, there are transcripts of the trial. I mean, the worst thing possible would
Well, I wonder, perhaps we should cut this short because we ought to give time to Mr. Bennett. We may never get there. If we do, this may be something on which we have to have further written submissions. Yes.
Well, firstly, on the issue, is there a ratio which binds this court? We say no, there isn't. And the test for you considering whether there is such a ratio is most recently set out, I have to say succinctly set out, in the authority passed up by Mr. Price this morning.
Well, I think we all know what a ratio is, don't we?
Yes, I'm just, if I may, there's just a take on this I'd like to refer you to.
Okay.
It's paragraph 33 of the Queen and Brent.
Kadim, in other words.
Kadim, pardon me. Just paragraph 33, page 1055 of the bundle, if you have that reference, bottom right hand corner. And you'll see the court there is dealing with the case where the law has just been assumed by a previous tribunal. If there's merely been an assumption, that is not a binding precedent. And we say that the authorities relied on by Mr. Price, some of them don't even go as far as that, but certainly none of them go beyond that. And it's quite apparent that the arguments put forward to you today by the claimant in this case have never been properly considered. And in fact, they've never been raised in a judgment. The interpretation of section 3.1 that's been relied on has very much gone through on the nod. Now, for reasons which it's impossible to speculate as to, it just hasn't been dealt with by a variety of tribunals, both at this level and the first instance level. And if we want to go down that route, well, we can equally rely on the case of Calvert, which preceded the three authorities that Mr. Price has relied upon. Now, I won't go into any further detail on those authorities, because the four appeal authorities at least, because I've relied upon those in the Skeleton argument and set up fairly detailed submissions there. All I would add in regard to Tinkler in the Court of Appeal is there simply is no ratio. To the extent it
There is no ratio. There's always a ratio.
well, to the extent it talks about what Section 3.1 means, and it's quite explicit on this, forgive me, I haven't got the precise reference, it just lets Mr. Justice Nicklin's analysis go through on the nod. There's no scrutiny of it. So in effect, you've got at most a first instance decision that supports Mr. Price's analysis of Section 3.1. And for the reasons we've outlined, we say that conclusion is wrong and fundamentally wrong. And again, if you want to talk about settled practice, we can equally fight back with reliance on Calvert, which is a Court of Appeal authority from 1963. But Calvert, if we're being frank, is similar to the other three cases relied on. You really have to struggle to take a ratio out of it. And there's information going in different directions. And the waters are muddied by, on some occasions, there's also a claim for common law tort, which means people talking about special damages, intermixing it, Jamil abuse, summary judgment. We say that those judgments don't really take this court anywhere. And what practitioners and members of the public are relying upon is this court to consider this meaning of Section 3.1 on the proper principles, subject to what Mr. Price and I would like to say is complete argument on the subject, which unfortunately hasn't taken place before. Moving on to the more, I might describe the micro points made by Mr. Price. And the first concerns the existence of the handbook. Now we say it's not reasonably foreseeable, objectively foreseeable that Miss George is going to show her employer a copy of the handbook. And at the very least, it's ironic, as my Lord Justice Snowden pointed out, part of the case in malice is proven by the fact that the first defendant was trying to prevent the claimant from obtaining a copy of the handbook. We say the lies in the Lingenfeld email led to the loss. It led to the ring fencing. It brought forward a cause of events which ended in Miss George resigning the following Sunday. And it's obvious it led to the ring fencing of the clients. It might be legitimate for Mr. Price to say, if we were contending for special damages, that the special damages have to be caused directly by the falsehood itself. But we're not dealing with special damages. And the mischief of Section 3.1 is clearly to avoid what we would say are sterile arguments about causation, which are put in the way of claimants such as Miss George. And it's also really not inevitable that, in effect, what Miss George did was take positive steps to mitigate her loss. After Mr. Lingenfeld had received the email, she took steps to mitigate. She wouldn't be penalised for that. But of course, it was just mitigation, because the lies led to adverse results for her. But for the lies, she would have stayed in that job and not had her client list ring-fenced and been prevented from earning commission. And it's difficult to, as a matter of black letter law, make this point. But what one's got to bear in mind is this is a case where malice is at its heart. As my Lord Justice Snowden pointed out, the intention, the stated intention in the email itself sent to Mr. Lingenfeld was, this is what her contract says. She's breaching it. You better stop her from doing that. And he does it. And there's also, of course, the threat to sue. And that threat, of course, matters strict pleading, it's not there. But the point, it follows from Mr. Justice saying, except there was no contractual term, there was no breach of contract. And Miss Cannell knew that. It therefore follows that Miss Cannell knew, as part of her warfare against Miss George, there was no prospect at all of her suing Miss George.
I mean, the reason I asked it, try and keep this quick, but if the respondent is correct, if you are the utterer of malicious falsehoods about somebody, you'd better hope that the person about which you are telling lies is actually sorry. You can say that if an objectively reasonable person would take steps to mitigate the effects of my lies or defend themselves against the adverse effect of my lies, I can take advantage of that in saying that there's no claim capable of being mounted against me. But the person who is more defenceless, not as switched on, will not be protected because they don't live up to the standards of the objectively reasonable person in defending themselves or mitigating the effect.
That's correct.
And that goes beyond the sort of normal, and my understanding of mitigation of loss, which is this: you just mustn't fail to do that, which an ordinary reasonable person would do. But there's no positive duty to do things.
No. And this was, of course,
this is the first thing I was trying to get through very badly, no doubt. But I can see why the test should be couched in objective terms, because that's to lower the barrier for people to bring claims rather than raise it.
Yes.
You don't have to establish an actual intention to cause loss. It's enough if you've got if the objective bystander would say, well, that's likely to cause loss. That's designed to lower the burden.
When you
claim, not, but it has the perverse. In this case, it could have the reverse impact of raising the barrier because it's the mitigating effect of the reasonable person.
It's when you compartmentalise Section 3.1 from malice, you get into that sort of analysis. But ultimately, you've got to bear them both in mind.
But other than the common ground that everybody says, oh, it's an objective test. I mean, I tried looking at it. I was trying to look to find out where that objective test comes from. And all the cases, even the old ones, say it's in the older authorities. Where does it actually come from?
I'm afraid I'm drawn from both sides of the court. There's been extensive examination of the authorities.
It comes from Ferguson, which is based on Article 10 considerations, not allowing it.
Well, no. Even the older, the objective test, I think, was mentioned much earlier in much older authorities, as coming from older authorities, long before Article 10 saw the light of day. I think is the point I was trying to make.
I think I can deal with this point quite quickly. The first time when the word calculated was introduced in case law was 1957 in a case called Custom.
Not 1976.
1976.
Hang on, the word calculated is in the Act.
My lord, the first time that the word calculated in the 1952 Act was accepted to mean likely was a New Zealand case called Custom Glass, because in their statute it was the same phrase. So I could give you the citation.
Well, I'm not sure that's quite my lord's point, but
No, okay. All right, I really don't. It's enough. I don't.
Yeah, I think it's an example how the previous cases haven't grappled with quite a number of issues which seem quite obvious on this hearing, but for some reason haven't appeared obvious at previous hearings. And certainly my analysis is the law has very much gone through on the nod before, without presumably advocates for the claimants really setting out the rationale that's been set out in our skeleton argument in these oral submissions. Just a few short points subject to any further questions from your lordships. A word that permeates Mr. Price's written and oral submissions is his suggestion that we on this side of the court are arguing for a tendency test. The extent it matters, we're not arguing for a tendency test. That word is used once in paragraph 16 of our skeleton argument. where I need to go to, it's paragraph 16, last sentence, where we just say the focus is on the words, the meaning of those words, and the inherent propensity or tendency of those words as a matter of likelihood, if published and found to be false, cause pecuniary loss to the claimant. So we're not asking for a tendency test, we're asking for the word calculated to be applied in what seems to be the consensus way, and the word likely to be used.
Just to clear this up, and maybe you're not saying that the circumstances of the publication are irrelevant in assessing whether the publication, circumstances in which the words were published are irrelevant in assessing whether they are calculated to cause pecuniary loss. Take the extreme point made by Mr. Price. Are you saying that your client could have sued if she had, if the defendant's statement had simply been made to a passerby in the street?
Well, that's where the mechanism test applied in Tesla comes in.
Well, this is all all right if you say so, but I don't like all these phrases.
Yes.
What's the answer to your question? What's the answer to my question?
Well,
would you say that you had a
short
nominal
answer is-
cause of action if she went out into if Ms. Cannell had gone out into the street, met a passerby and said, "You know, Miss George is poaching all my clients in breach of her contract"? That wouldn't be calculated to cause. Words might be calculated to, but the publication wouldn't be.
No.
And are you saying that that doesn't matter? Nevertheless, in principle, you could have had a cause of action.
That injustice is protected against, and I'm sorry to refer to some of the outside experts, it is protected by the Jamil jurisdiction.
All right, so you're saying that subject to abuse, formally, that would in those circumstances be a cause of action?
Which would be struck out immediately.
All right, okay.
It's, that's
Publication of thing to a room of people who can't hear it because the microphone is switched off, or
Yes.
because they're deaf or whatever, is nonetheless actionable.
Well, no, because there'd be no.
Very unattractive submission. Why do you think you need to make it?
Well, it's the wording of the statute. It's not necessary on my facts, but for a full consideration of how this works. And really, my submission to sort of labour on about the Jamil jurisdiction is the court shouldn't be too concerned about Section 3.1 if interpreted literally having unfair consequences because of the checks and balances introduced by Jamil and by the mechanism. But fortunately, my facts are very far beyond those of words being spoken to a passerby. The last point is just a point made in an academic journal, which summarises really the Strasbourg jurisprudence on the value of Article 10. And the value of Article 10 isn't an absolute. It doesn't apply in the same way that it applies to the defendants in compared to, for instance, a journalist writing an article in the public interest. The academic journal I rely on is in bundle 2 of the authorities, page 47, tab 47, pardon me. And this is a professor of law of jurisprudence at Oxford University, and he's assessed and grappled with, rather than just saying, as Mr. Price would, well, Article 10, that's considered in the same way every time. No, it isn't. There's a fact-sensitive exercise which looks
Show us the passage.
at the type of speech. It's page 1029. You'll see the opening subheading is high and low value speech.
Well, how much of it would you like us to read?
Yes, well, the first paragraph deals with high value speech. You can just skim that.
Yeah.
And second page, first complete paragraph, page 1030, begins with the words, while political speech has the highest value, then it looks at lower value speech, such as hate speech and gratuitous personal attacks. And we say, if to any extent this court feels it needs to deal with Article 10, this assertion of an Article 10 right to freedom of speech somehow affecting the court's decision is at the bottom of the barrel. It's a scraping of the barrel, because this is speech which was spoken with the knowledge it was false, and on the finding of malice, it was spoken with the knowledge that, or intention that it would cause harm, as evidenced by the particular words spoken by Miss Canal, the first defendant. My lords, unless I can be of any further assistance.
No. Thank you both very much. We will be reserving our decision, as you know, but just to say this for the benefit of other people in court, what that means is that in due course a draft judgment or judgments will be circulated. That is for the purpose, context of this case in particular, perhaps the point needs to be made, that is for the purpose not of re-arguing the case, but simply to allow the parties to prepare any submissions on consequential matters, and to prepare for the publication of the judgment generally, and to draw to our attention any typographical or other minor factual errors. You will be aware of the recent decision of this court in the Counsel General of Wales case, making it very clear that the publication should only be to those people who need to see it for those purposes. And if there is a breach of the embargo, there is a risk of the parties responsible being held in contempt of court. You can always reread Counsel General for Wales if you have any doubt about what your obligations are. I don't suppose that's a particular problem in this case,
No,
but it has to be said in every case now.
Yes, I think we all live in terror having read that case.
That's no doubt the intention. Right. Thank you very much.
Court was